Welcome everyone. I am extremely delighted to be interviewing Sally Harpole today as part of the ITA's Oral History Project, Preserving Perspectives of International Arbitrators in Their Own Words. The project seeks to capture quite literally the voices of the most eminent arbitrators across the world, and we're very grateful to Sally for agreeing to be interviewed. I would also like to record my thanks to the University of Pacific, my home institution, for hosting this interview. Sally Harpole is a prominent international arbitrator, mediator, and attorney at law. She has served in one of those capacities in over 125 international commercial cases under the rules of various arbitral institutions, including the China International Economic and Trade Arbitration Commission, otherwise known as CTEC, the Shanghai International Arbitration Center, the Hong Kong International Arbitration Center, the Singapore International Arbitration Center, the Chinese Arbitration Association in Taiwan, and the Korean Commercial Arbitration Board, among others. Since 1977, she has focused on investment, trade, technology, licensing, and disputes for transactions between multinational corporations and Chinese and other Asian parties in a wide range of industries. As an attorney qualified in California and in Hong Kong, she led the China practices of multinational law firms in both Beijing and Hong Kong for nearly 3 decades before establishing full-time practice as an independent arbitrator. After 36 years in Asia, she moved back to the US and is currently based here in San Francisco, California. Sally has scored many firsts in the world of international arbitration, including being the first non-Chinese arbitrator to be awarded with CTEC Honors Arbitrator distinction, and is among the first Chinese named to the CTEC Arbitrations Panel and CTEC Commission. She has been cited as a leading international arbitrator and lawyer in peer and expert surveys such as the Global Arbitration Review, Top Women in Arbitration, Chambers Leading Lawyers, and the Asia Pacific Legal 500, and others. She has also served in leadership roles in numerous prominent professional and business organizations, including as president for 2 terms at the American Chamber of Commerce in the People's Republic of China, 10 years on the Council of HKIAC, several years on the board of directors of AAA/ICDR, including as chair of its Asia Advisory Council for a number of years. She also served for a few years on the commission of CTEC, as well as being a co-chair of the arbitration committee of IBA for a couple of years, and the list goes on. On top of all of that, Sally has also somehow managed to find time to serve as an adjunct professor at the UC College of the Law in San Francisco, and as a visiting professor at the Straus Institute for Dispute Resolution at Pepperdine University Law School, and has also lectured on arbitration at the law faculties of numerous universities in China. She has also served on the editorial boards of the World Arbitration and Mediation Review and the CCH China Business Law Guide, and has published various articles and book chapters. You've been awfully busy, Sally. Thank you again for agreeing to come on camera to share your experiences and wisdom in this field.
Oh, that's very kind and generous of you, Jarrod. It's a great pleasure to be here, and I think a lot of ITA is a wonderful organization. I feel very honored to be included in this project.
And we're very, very grateful that you said yes. Did you always know you were going to be an attorney?
I cannot say that I always knew. I was very interested in being a teacher. So perhaps there's a connection. I think law practice can be rather pedantic. It has that side, so perhaps there's a link there. But after finding the opportunities that existed in the legal profession, I certainly was then pointed in that direction.
So let's start right at the beginning of your legal studies. When you were in law school at the University of Washington in Seattle, were you already piqued by international law?
Certainly, the interest in international law was already there when I went to the University of Washington. I chose that very fine law faculty because of their Asian law program. which had been founded by Dan Fenno-Henderson, who is a pioneer in Japanese law comparative studies. So I naturally gravitated to that environment for my law study.
And the school already had an LLM program, did it not, at that point?
Yes, they had an LLM program specifically for students from Asia who had been practicing lawyers or academics who wanted to do comparative law studies between comparing Asian law systems with the US. They also offered courses in Japanese law, Japanese comparative law, and I might add, in my field, Chinese law, which I was interested in, did not exist at the time that I was in law school because the Cultural Revolution was still raging at that time. But there was one Chinese law class that did open up in my final year of law school, and that was Chinese law of the Qing Dynasty, reaching into historic legal background of China. So that was an interesting opportunity to learn about law in China as it existed.
Yeah, that must have been a fascinating class.
It was great.
Now, you were already fluent in Chinese by the time you got to law school. How did you end up in this position?
Oh, well, I decided I wanted to learn Chinese when I was at University of California at Berkeley. I plunged into a Chinese class in my final year. I was the only non-Chinese in the class, so I knew I had to work hard. And 1 week after graduation from Cal, I took a one-way charter flight to Taiwan and stayed there for 3 years of total immersion. I actually had 5 Chinese roommates in one dormitory room at the University of Taiwan.
Were you taking classes there as well?
Oh yes, I was. I enrolled as a regular matriculating student in the graduate history program and studied modern Chinese history at Taiwan University.
Yes, and that put you in a really great position, even in law school, because you had the most amazing summer internship, as it were. You were, I think, serving as a translator, doing freelance work while you were a student at law school.
Well, yes. I was very fortunate. It was partly a matter of timing because business connections with the People's Republic of China were just beginning when I entered law school in 1975. The total opening hadn't taken place. U.S.-China diplomatic relations were not established until the end of 1978, but between 1975 and 1978, leading up to that time, there were some initial business contacts, and of course people needed somebody to help with communication. So I found the opportunity to work as a translator in trade negotiations during my vacation time, and helped to finance my law school education that way.
So when you first visited China as a translator for these companies, was China just beginning to open up to the world?
I would say it was barely opening up. At that time, the people that we dealt with in China, they would have been purchasers of textiles, purchasers of oil field equipment, were more interested in politics than they were in business. So we, at that time, when we went to meetings, we received instructions about political viewpoints at that time, and it was quite difficult to actually transact a complete contract relationship. But some of my clients did. My client in the textile area actually did make purchases, and very successfully, but it was a very, very early stage of commercial relations between China and the outside world.
And from there, though, you seem quite determined then to have a practice in China, although that didn't come right away from law school. What was your first job when you graduated?
My first job was in a law firm. I did a little research before I planned my interviews for positions after graduation, and decided that Yes, there were 3 firms that were already in Asia. Those 3 firms were probably the most likely to open an office in Beijing once that became a possibility. And of those 3 firms, one had an office in Los Angeles where I thought starting practice would make sense, being a person from California and Los Angeles being such an enormous commercial center. So I interviewed with that firm, Graham and James, and met a partner who himself was interested in the future possibility of China. After interviewing with the partners there and mentioning to them along the way that I was going to be part of the American Bar Association delegation to China in 1978, a very early opportunity. The next morning they called and hired me.
Very wise of them, as it turns out, Kaylee. So tell us a little bit about the early years of your career as a transactional attorney in the firm.
I love transactional practice. I was mentored by a wonderful lawyer by the name of Yasuhiro Hagihara, and Mr. Hagihara had a broad list of Japanese clients, trading companies, banks, many prominent Japanese companies, and they were very active in the United States, in California at that time, being the late 1970s and early 1980s. That was a huge period of time for Japanese business in the US. So I had exposure to a very wide range of types of transactions, contracts, and also the experience of working with Asian clients and with an Asian mentor. So I enjoyed that type of practice from day one. It was a wonderful experience.
Right, and with you on board, obviously Graham and James was looking to open an office in China and did eventually get there. So how did that transpire?
Oh, that's another unusual story where I think we got very lucky. My partner, David Hayden, who is another important professional mentor, went to Beijing on his sabbatical just to explore and see what types of opportunities there might be for somebody who provided legal advice to multinationals who were exploring themselves commercial opportunities at the early stage. This was in 1981. And one of our clients was selected to be the first foreign invested hotel in China. That was a major breakthrough. And so David contacted me and said, I really need somebody to continue to be present, to provide legal advice, even though my sabbatical is coming up. I need to go back at the end of that period. So I agreed, and we agreed that it would be something we'd try out for 6 months rather. So I packed a bag with 6 months worth of clothing, and 6 months became 7 years before we knew it.
That's incredible. And you were a mid-level associate, is that right, when you first took on this enormous responsibility?
Yes, I felt the weight of the responsibility, but it was so exciting. It was an irresistible opportunity. I did receive, of course, plenty of guidance from the firm, but it was definitely an early stage in my professional career to be on my own, launching an office on my own in Beijing.
What sort of regulatory hurdles did you have to encounter?
Well, we were dealing in a gray area at that time. It was no secret that we were there. We were well known by the local Chinese officials and universities and the people that our clients were doing business with. But at the same time, a legal regime for the registration of foreign lawyers had yet to come into being. And so we did not have a way to make our presence formalized or official. This, of course, created a number of complications, including difficulty in bringing office equipment to use. So there were some complications, there were some obstacles, but when you're in an environment like that and with interesting projects that needed to be served, they cried out for service, you find a way. to get through it. I would actually say that our first joint venture contract was typed on an electric typewriter with carbon paper because we had no photocopier.
Wow, yes, that's a very different world. Yeah. So how long were you the only practitioner in your office when you first began?
Great question. I think after a year or so, I found a lovely individual who had come to China with his wife, who had a career opportunity. He was teaching law at Beijing University and wanted to link up with a law firm. So I immediately introduced him to the firm, and the next thing I knew, I had an associate working with me. So very quickly we had 2 people, and then gradually after that we were able to build up the staff that we needed in order to serve multiple clients.
Did you work with Chinese law firms in this process? You must have had to. And what was that like?
That was what I regard as a very important part of the practice. When I first started working in China, there was no legal profession. It had been abolished, as you probably know, during the Cultural Revolution. But shortly after I started working in China, the Cultural Revolution by that time had ended. The key universities had started to revive their law faculties and gradually began to produce lawyers. There also were people who were law trained prior to the Cultural Revolution who came back. And these were very erudite, highly skilled legal experts who simply had not been permitted to exercise their profession during the Cultural Revolution. So we had the very old and the very new, very talented people. It was an interesting time when the Chinese legal profession came back into being. I immediately saw the value in teaming up with Chinese law firms. They would come with a different understanding of the law, a deeper understanding of the regulatory regime, and I found that it was very good for our clients also to provide a team approach to some of the problems that we're being asked to handle.
So was the firm in a position to hire Chinese attorneys?
That would have been a wonderful opportunity. We certainly did need law-trained people from China, locals, in the office for numerous purposes, including handling Chinese language documents, helping with research, etc. But because of the regulatory framework that had been set up through the Ministry of Justice, a licensed Chinese lawyer would be required to work in a recognized Chinese law firm. So a law-trained local who was at a foreign law firm could work as a consultant, but not in the capacity of licensed Chinese lawyer. So these are special aspects of the local regulatory framework that we had to adjust to, and of course at all times make sure that we were in compliance with these requirements.
So you had an entire life as a transactional attorney. How did you get from there to becoming an arbitrator? What was that transition like?
It was quite a remarkable transition, Jarrod. I don't know any other way to describe it, and totally unexpected. Unbeknownst to me, the CTAC, the China International Economic and Trade Arbitration Commission, which at that time in the 80s, that we're now talking in the 1980s, at that time was the only nationwide arbitral commission that could handle international cases in the People's Republic of China. They had been told by many international arbitration leaders that in order to be truly international, they needed to include non-Chinese locals on their arbitrator panel, but they simply had not done it for various reasons. To my surprise, they made the internal decision that they would invite a few. In fact, they invited 3, and I was one of those people in June of 1989. An extreme honor, total surprise, and just to give you a feel for what happened, I was by that time in Hong Kong. I transferred to Hong Kong in the late 1987 to continue our China practice and to manage both Hong Kong and Beijing. And a message came through my telex machine. At that time we had telex machines with tape running through, and it said, would you be willing to consider a low-paying but very interesting job? Would you accept appointment to the CTAC arbitrator panel? So I didn't have to think very long after I saw that message. I almost immediately accepted. To me, this was an opportunity that was very important. It would help CTAC with its internationalization. It would help multinational clients with the opportunity to choose whether they want to appoint a local or international arbitrator. I very much wanted to be part of that. So I quickly accepted that, and this became news in the arbitration world that 3 non-Chinese arbitrators had been added to the CTAC panel. It was an important moment.
Up to this point, your exposure to arbitration has been as a transactional attorney. I mean, I assume that you had seen many arbitration clauses in the contracts, and perhaps introduced them yourself in the contracts that you negotiated. And so there must have been a huge learning curve at this point when you realized that you were going to need to learn about arbitration, this really new emerging field in China, as it were, at the time.
That's very much the case. Frankly, as a transactional lawyer, I always made it my job to try to persuade clients against going into contentious procedures with their counterparts. I regarded my position as one of avoiding conflict and helping clients to work their way out of conflicts without having to go into litigation, for example. So it was interesting to suddenly be in a position where I could be part of the dispute resolution procedure. I fortunately was in Hong Kong at the time that this opportunity came about, and that was a moment when arbitration education, the pool of experts, arbitration experts that were in Hong Kong was very robust. So I had many places to go where I could learn. I entered intensive educational courses, tried to absorb as much as possible once I knew that I was going to have this opportunity to work in arbitration.
And that led to your first arbitration as an arbitrator in Hong Kong.
It certainly did. My first appointment was in Hong Kong. It was actually a AAA case with a 3 arbitrator panel and an international case, and I sat with 2 very experienced co-arbitrators and enjoyed the experience very, very much. After that, I started to get CTAC appointments for cases with CTAC that took place in Beijing, also in Shenzhen. So the opportunity to serve as an arbitrator began to unfold.
Do you recall your impressions of whether these arbitrations in CTAC and in HKIAC were different in any respects at that time? Or were CTAC arbitrations essentially riding off of HKIAC arbitrations in terms of their format and the templates that were being used?
I would say that the differences, between Hong Kong International Arbitration Center and CTAC, as an example of a Chinese arbitral body, were much greater in the early days than they are today. I think there's been a lot of harmonization over the last few decades in arbitral procedures worldwide, including between China and other places in the world. But I would say in the case of CTAC, some of the outstanding features which were less obvious in Hong Kong, which at that time was still following an English system, included the role of the institution. Arbitration was very much an institutional procedure in China. In fact, it could only be conducted through institutions, could not be conducted ad hoc. And so the institution played quite a strong role in administering the procedure, much stronger than the arbitrators. The arbitrators oftentimes had to look to the institution to make decisions such as jurisdiction, which was different from the situation in Hong Kong. Other than that, it depended on the parties. CTAC arbitration rules, at least from late 80s, early 90s, at least from that point in time, were flexible enough to permit parties to mold the form and approach of their procedure if they could mutually agree. So there was space for that. I would say that some parties better understood how to navigate that than others, and of course it still was an issue of mutual agreement. So if both parties didn't want to use a more Western approach to arbitration, then the default would be the way in which the rules actually set forth, which included that the procedure would be operated in Chinese language.
Right. And how did the differences in legal culture manifest in the way arbitrators saw their role on CTAC as opposed to at HKIAC, would you say?
The arbitrators, of course, those that came from China came from a civil law background. And the experiences that I had with them were very similar to experiences that I've had with civil law lawyers from Europe who serve as arbitrators. They very much had an approach that focused more on documents than witnesses. It focused on the letter of the law and the letter of the contract rather than case precedents, common law considerations. And that there was basically a familiar approach, I would say, when I sat with a local Chinese lawyer, or many times it would be a retired Chinese judge on a CTAC panel, as compared with in Hong Kong, where oftentimes the people I sat with were English barristers or Canadian solicitors or people that had a more Western or stronger common law legal culture background. So there were differences. It sometimes depended on who was sitting on the tribunal. In both cases, between Hong Kong and China, in both cases, there was an attempt to leave a lot of space for party autonomy. So I would not say that CTAC limited the parties' ability to have a more Western approach to their procedures, but there was a tendency to go more in a common law direction in Hong Kong because of the people who were being appointed as arbitrators.
And were these proceedings conducted in Chinese, in English, or in both languages?
I have basically had all experiences. Some of the arbitral procedures that I've participated in as arbitrator were conducted entirely in Chinese, both written documents and the hearings that took place. Some were bilingual, where we had translators through the whole procedure and key portions of documents had to be translated, a lot of bilingual approaches, and also all English language. And I would say that these possibilities, all of these variations, have been possible both at CTAC and in the Hong Kong International Arbitration Center, depending upon what the parties decide. The key in CTAC arbitrations, because of the way in which the rules are made, is that if the parties do not agree, if they do not reach a mutual agreement on the language approach, the language will be Chinese. When that happens, CTAC does provide translation support when parties need that, or when a foreign arbitrator needs that. But Chinese language tends to be a much more important element in a China-based arbitration as compared with an arbitration in Hong Kong, where also parties may mutually agree to have their arbitrations entirely in Chinese, but it's much more common to have a bilingual or English language only procedure in Hong Kong because of the legal community that is there.
And this must also in turn have impacted the choice of counsel representing these various parties. did they tend to be Chinese law firms, or did they also include? So is international arbitration to the extent that they're taught in Chinese?
It certainly is
and
both.
How do what do students perceive of this?
The Chinese legal profession has
There
come
are
a long way
some
in a short period
law
of time,
faculties where
there are
an
many
international
skilled
arbitration,
Chinese counsel
education is
who
available.
have experience
Not all, but
internationally
certainly some.
as international
And,
arbitration counsel, and
any Chinese lawyer who is
they
involved in
are
international
very happy
or
to
foreign
serve
related,
Chinese clients or
dispute work
clients who
will
are from
certainly
other countries
contact
in
with
arbitration
as an important part of their
the
practice.
point where their service becomes
is a
particularly
jurisdiction
important
that has
is in
encouraged
China
the
when there
use
is a
of
Chinese
arbitration
law
as a dispute
question
resolution
in the
method.
dispute. So unavoidably,
Those cases,
it's an
there
area
is
of great importance
some
for
authority
Chinese practitioners
in the
who is
regulations
involved
of the
in
Ministry
dispute
of Justice
that
So,
Chinese
what advice
licensed
would you then
counsel
give
must be
law
used
law students
to
and young
represent
professionals today,
clients
whether
for
here in the
matters that
U.S.
are governed by
or in
Chinese
China?
law.
Your advice may be
So
different
they're
depending on
the
where
role
they're
of the
located.
Chinese client.
As to what they should be thinking about or looking to do, if they
Hong
wish
Kong
to embark
is
on a career
much more wide
in
open
international
in
arbitration.
terms of permitting
Well, I think,
international counsel.
it's a great
from
field.
anywhere.
I certainly
to
would
represent
encourage,
their clients. Clients have total
any
autonomy, as
young
we do now in
professional who
California also
feels the interest
for
to
international
try to get
arbitration
involved in
disputes.
international arbitration.
There is not that
Learn about it.
limitation. Parties
Fundamental
can freely
is,
choose, but so
learning
often
good legal skills
the
to start with.
arbitrations
I
value
that
very
we
much
have
involve
opportunity,
Chinese
the
law.
opportunity I
The ones
have
that I, as a
called
transactional
to
lawyer,
serve
for
as
somebody
arbitrator
that immediately
goes
tends
into
to have Chinese law
litigation
issues.
or dispute
Oftentimes the reason
resolution
the
work
counsel
at the
appoint me.
beginning, you try to
And
get
in
as
those
much
cases,
exposure
it's not
to
unusual to
as
see a
broad
team of
base
lawyers representing
commercial
a client.
work, intellectual
I've had
property work,
arbitrations
whatever
where
field,
teams of
three
you're
different law
interested in,
firms,
but try to really
or a
learn the
barrister
legal
and two
basics.
law firms,
The basics
of
have
the
joined
practice.
together to
That will always
represent the
serve
client
you,
on all of the different
when going in
legal
then
issues
to
that
have
have to be
case
addressed
for
in a contract.
international
That happens
arbitration.
sometimes.
And
There's
what
a
about
lot
experts? Would
activity
each
outside
party
of
produce an
law
expert,
firm
or
work. ITA
or would it
is
be
a
more in line
beautiful
with the civil
example,
tradition where the
where there are
tribunal would in
conferences,
fact appoint
there
a
are
single
gatherings
expert?
of experts for the exchange of experience.
Well, you're right.
networking
It's
opportunities.
in the
CTACT
I think all of these
arbitration,
things
it
become
would be more
important
common
for
for somebody
the
who actually
tribunal
wants to make
to
international
find an
arbitration
expert
with
there,
the parties' mutual agreement.
career.
It's important to
Parties
know who's in the field,
may
to
present
understand
experts,
what
but
practices
again,
people are
because it is a
adopting.
civil law
And,
environment,
with
the role of
ITA
the
and
organizations
organizations
like
or the
ITA,
role of any witness,
there are
whether
great
it's a fact
opportunities
witness
to do
or
that.
an evidentiary
Well, thank you so much.
witness,
And we're really, again, very grateful
tends
that you've
to
agreed
not
to
be
do this
as
interview. It's been an
important as
incredibly
documents.
rewarding
And this is something that
fascinating
counsel is
conversation.
aware of when they plan
Um,
the presentation of their case.
And so, with
I
that,
have
we'll
found
close this
as
interview.
an
Thank you.
arbitrator
Thank
in the
you,
CTAC
Jarrod. It's been a great
arbitration
pleasure.
that it's not always easy to find experts.
Great.
But we
Sorry,
have,
was there anything else that we-
on a few occasions where, very complicated technical issues required an expert investigation and opinion, that we needed to get the parties' agreement to appoint somebody. And the selection and the questions we were going to ask, of course, is something that I always like to keep very transparent. But this is, as you said, more an issue of the tribunal organizing the proceedings than counsel. The opposite in an environment such as a Hong Kong arbitration in general.
Yeah, one other area I'm thinking of that may present differences between CTAC and other tribunals might be with regard to discovery. Was discovery available, and if so, what did it ordinarily just focus on documents?
Well, it's not that different from the situation with an expert witness. Under CTAC rules, the tribunal can rather robustly request evidence from the parties, and that oftentimes does happen. A tribunal will say to a party, I want to see this document, that document. That happens, and parties have to be ready for tribunals to request that. It's less common for a tribunal to authorize one party to require a document from another party. as we know in a document production procedure that would take place in Hong Kong or in other locations. So discovery, as we know it in the US, certainly is not existent. Nothing that far-reaching or wide open, but securing some form of document production is available. It's just that one needs to know how to do it within that system. What we do find is very important in a China-based arbitration is the authentication and verification of documents. Because it is a document-driven legal system, being a civil law system, the verification and authentication of the documents that are presented by each side is something that we do devote time to and go through in a fair amount of detail.
Now, when you were first appointed to the CTEC panel, as you mentioned, you were one of 3 non-Chinese. Has the profile changed radically since then? Is the composition, I guess, of the panelists, does it include more foreigners today?
Yes, I would say radically is a good word. There is quite a long list of international arbitrators on the CTEC panel today. And also, I might mention, on the panels of the other leading Chinese arbitral bodies that handle international cases, such as in Shanghai and in Shenzhen, for example. There are many people who CTEC has reviewed and invited to serve as arbitrators, and therefore parties have a much longer list today to choose from when they want to nominate an arbitrator to serve on a CTEC panel as compared with before. It's come a long way. It's more than 100. I think the question is, how often do these international arbitrators get actually appointed in a CTEC case? Not that often. And there are a few reasons for that. One is that if they are not fluent in Chinese language, it may not be considered convenient to appoint them. So many procedures are in Chinese. Or if they are not fluent in understanding Chinese business transactions and the legal aspects of Chinese transactions, that might also be a limitation. So one has to understand the perspective of what a party is looking for when they're appointing an arbitrator, what CTEC is looking for if they're in the position of being the appointing body, and to what extent the many international arbitrators who are on the list would match up with the requirements of a given case.
Although the legal landscape too has changed, as you know, it's not just the number of international arbitrators on CTEC's panel that has increased. The number of arbitral institutions in China have exponentially grown over the last few years. Can you tell us a little bit about this development?
Yes, that is a very interesting development, and one that's important to understand if one wants to see the entire landscape that's there for arbitration in China. Since the promulgation in the 1990s of the arbitration law of the People's Republic of China, that established the foundation for other arbitral institutions to develop as international bodies that accepted international cases between Chinese and non-Chinese legal entities and individuals. And as a result, we saw a proliferation of new arbitral bodies opening up, and some of them have developed very well. I would particularly mention the Beijing Arbitration Commission, the Shanghai International Arbitration Center, the Shenzhen Court of International Arbitration, as a few examples of particularly respected new arbitrations. It has created a healthy competition among the leading arbitral bodies that handle international cases, which of course has led to a lot of updating and modernization of rules, which has been good for everybody. Apart from that, there are a few hundred domestic arbitration commissions throughout the country. So the arbitration culture in China is very strong. Both domestic cases and international cases are extremely numerous, according to the statistics that we're seeing.
And what's the enforcement picture like when you compare, between the domestic institutions and those institutions that can handle international arbitrations? Are the awards typically and uniformly enforced in China?
This is the hot topic that so many people want to know about. Of course, at the end of the day, the question that every party will ask is, will my award, if I receive an award, be enforceable, if it needs to be enforced in the People's Republic of China? It's important to bear in mind that China did accede to the New York Convention on the recognition and enforcement of foreign arbitral awards. It was one of the earlier members of the New York Convention within the entire Asia landscape, although I would say quickly after China acceded, we saw many other Asian countries join the New York Convention. And so the enforcement of foreign arbitral awards in China is on the basis of the New York Convention. The Chinese civil procedure law has been drafted with respect to the enforcement of foreign arbitral awards to be basically a mirror image of what the New York Convention provides. So the legal framework is there. The question is what happens in practice. And given the fact that the courts that are charged with handling the enforcement of a foreign arbitral award are somewhat localized, there is concern about whether local considerations will come into place. That's one of the issues that comes up. The statistics show that most foreign arbitral awards do get enforced, but there have been some outliers. The other thing is that when China acceded to the New York Convention, it did take the commercial exception, it did take the public policy exception, and I would say that among commentators, one of the topics that gets particular attention is how and when will the public policy exception come into play. That's not been an issue in many case precedents so far. It's there though, and as long as it's there, I think it will receive scrutiny and attention.
Of course, the public policy exception exists for all countries that are party to the New York Convention, potentially, and so it's not unique to China, right? That there might be concerns about those outlier situations, but they are, for the most part, outlier situations. Are there, when you look back at the many arbitrations that you've served on as an arbitrator, are there any memorable arbitrations that stand out to you today?
They're all memorable. Each one is unique. I cannot say that I've had, because of the nature of the types of cases that I tend to be appointed for, each one is very unique. I've sat in arbitrations with nationalities from every continent, and so there are cultural differences in some of the arbitrations. And then certainly who is counsel has an impact on the experience of being an arbitrator in the procedure. And we've seen counsel that are very familiar with international arbitration, can very smoothly work with the counsel that is representing the opposing party. And we've also had, some arbitrations where the counsel's relationship is quite combated, where they don't get along as well, and then the tribunal is called upon to try to keep the procedure going smoothly in spite of problems on that front. So each arbitration takes on a unique character. I do enjoy the variety in my work. It's one of the things that delights me most about the work of being an arbitrator.
You mentioned earlier that in many instances, at least when CTAC was a fledgling institution, the tribunal often looked to the institution itself to manage the process in important respects. Has that changed over the years? Has the tribunal gained more autonomy, more recently?
I think the answer would have to be yes. I think that CTAC itself has taken on board the need to allow a tribunal to direct more aspects of the procedure. I'm hearing more about tribunal stepping into a arbitration with early stage meetings with parties, for example, preliminary meetings with counsel, pre-hearing meetings with counsel, so that rather than having the CTAC secretariat necessarily be the party that does all the organization and preparation and consulting with the parties, some tribunals now are stepping in and themselves being more proactive in understanding what the parties' needs are with the arbitration, organizing hearings in the way that they need to be handled, and even handling preliminary subjects. These are the kinds of more active tribunal roles that we've come to see quite frequently in other countries, in Hong Kong and Singapore, in other jurisdictions, I should say, in other continents. And now I see that that's available in China. It does come back to the question of who is on the tribunal. Is it somebody who is forward-thinking in that respect? And it also comes down to the counsel. Are the counsel requesting the tribunal to take that role? So I think it is a matter of having experienced practitioners on the counsel side and on the arbitrator side who understand the possibilities of how they can work together.
Would you say that these changes that you've identified that they were spurred by the competition provided by the other powerhouses in Asia, like Singapore and Hong Kong's International Arbitration Center? What has that competition fueled?
That is exactly the case, is that all of these arbitral institutions are quite close. Each one is very aware of what the other is doing, and that's helpful. They learn from each other, and they spur each other to try to keep up with party expectations. I mean, at the end of the day, it's all about serving parties. And party expectations, I think, have been bolstered by the readiness of powerhouse arbitral bodies like the HKIAC, the SIAC, and CTAC, for example, and other leading Chinese commissions. They've been bolstered by seeing the possibilities of what you can do. And none of them seem to feel limited in their ability to present to parties what parties want. They all are interested in stepping forward and being able to accept and provide administrative services to what today's party is requiring.
So when you look back to see how far all these institutions have come, and from this vantage point looking forward, what do you see is the future of international arbitration, particularly in Asia?
I have a few takeaways from looking back. I mean, one takeaway, which perhaps nowadays people don't think about, but taking my experience of going back to the late 1980s, is the fact that the institution holds an incredibly important role. That was not so much the case when I first started. There were a lot of people doing ad hoc arbitration. That's still a possibility today. But what has happened is that institutions like HKIAC, which was formed in the middle of the 1980s, SIAC, which started operating independently in 1991, if I have the date right, and CTAC and the other institutions in China that handle international arbitration, they've developed themselves into very strong institutions which are very service-oriented. That's very attractive to parties and their counsel. And by doing that, they've made themselves more important in the whole arbitration scene. So we are now more focused on the institutions today in Asia than perhaps might have been the case a few decades ago. The other thing I would say is that I think that arbitration is alive and well as a dispute resolution method. The case numbers continue to increase, they continue to be strong, and the most promising thing, and I'll say this to you as a professor, is that there are so many students who are interested in learning about arbitration. And this has now become a career goal for young people to get into the arbitration field. That was non-existent a few decades ago. So I think there's a lot of energy and stimulation in this field, and certainly a lot of room for growth. The final thing I'd like to say, just in terms of takeaways, is the important role of mediation, conciliation, and settlement. CTAC was a pioneer in putting on the table the encouragement to conciliate or settle the case without having to go through an entire arbitral procedure. That has always been a cornerstone of CTAC procedures. Since CTAC is basically an entity that has provided a template for the other arbitral institutions in China, that's pretty much part of the nationwide character of arbitration in China. And what I've seen is, with Chinese related arbitration becoming so important to the market in Hong Kong and Singapore, both HKIC and SIAC came around to incorporate in their rules more express permissions for parties to implement mediation and settlement techniques in the course of an arbitration. We now see that AAA ICDR has done that. The ICC recently came out with a very important paper on settlement procedures that could be adopted in the course of an arbitral procedure. And so now the role of conciliation, mediation, settlement, whatever type of technique parties want to use to find an amicable solution to their conflict without necessarily having to go through the entire arbitral procedure up to an award, seems to be a hot issue. I mentioned also, of course, the Singapore Mediation Convention, which goes beyond our conversation, but that's part of the story. And so in looking to the future, I think there's no question that that is going to be a continuing story that will have probably some very exciting further developments.
No doubt. Many of these mediation, conciliation mechanisms remain voluntary, presumably. Have you, nonetheless, because of this focus on these other ADR methods, do you see it changing the practice of parties on the ground in terms of what they're thinking about before they launch into arbitration proceedings?
I think that it has expanded the range of options in terms of procedures and techniques that are available to the parties. This may cause counsel to spend more time talking with their clients about these options. And so it has stimulated, I think, more attempts to use those avenues for the resolution of conflict. Whether they actually end up with a successful ending, of course, depends on each circumstance, but it does seem that both tribunal and counsel are more focused on that than they used to be, and are more willing to give that some attention and to give it a try, which of course is always the beginning of that type of process.
Right. Well, you mentioned as well that the legal education landscape has changed. So is international arbitration a class that gets taught in Chinese law schools? And what do students perceive of this discipline?
There are some law faculties where an international arbitration education is available. Not all, but certainly some. And any Chinese lawyer who is involved in international or foreign related dispute work will certainly come into contact with arbitration as an important part of their practice. China historically is a jurisdiction that has encouraged the use of arbitration as a dispute resolution method, so unavoidably it's an area of great importance for a Chinese practitioner who is involved in dispute resolution.
So what advice would you then give law students and young professionals today, whether here in the US or in China? Your advice may be different depending on where they're located, as to what they should be thinking about or looking to do, if they wish to embark on a career in international arbitration.
Well, I think it's a great field. I certainly would encourage any young professional who feels the interest to try to get involved in international arbitration, learn about it. Fundamental is learning good legal skills to start with. I value very much my opportunity, the opportunity I had as a transactional lawyer. For somebody that immediately goes into litigation or dispute resolution work at the beginning, you try to get as much exposure to as broad a base of commercial work, intellectual property work, whatever field you're interested in, but try to really learn the legal basics, the basics of the practice. That will always serve you when going in then into handling casework for international arbitration. There's a lot of activity outside of law firm work. ITA is a beautiful example where there are conferences, there are gatherings of experts for the exchange of experience, networking opportunities. I think all of these things become important for somebody who actually wants to make international arbitration their career. It's important to know who's in the field, to understand what practices people are adopting. And with ITA and organizations like ITA, there are great opportunities to do that.
Well, thank you so much. And we're really, again, very grateful that you've agreed to do this interview. It's been an incredibly rewarding, fascinating conversation. And so with that, we will close this interview. Thank you.
Thank you, Jarrod. It's been a great pleasure.